Hello, I'm Richard Wilson. I'm the Case Manager at the Standards Commission for Scotland. This short video outlines what happens when you can make a complaint about a local authority councillor or a board member of a devolved public body in Scotland. The Standards Commission was established by the Ethical Standards in Public Life, etc. Scotland Act 2000. It's an independent public body responsible for encouraging high standards in public life in Scotland. The role of the Standards Commission is to promote the codes of conduct covering the behaviour of councillors and those appointed to the boards of devolved public bodies, to issue guidance to councils and devolved public bodies on how the codes should be interpreted, and to adjudicate on alleged breaches of the codes of conduct by councillors and members of devolved public bodies, and, where a breach is found, to apply a sanction. The Ethical Standards Commissioner, or ESC, is a separate and distinct office holder who is responsible for investigating complaints that councillors and members of devolved public bodies have breached their respective codes of conduct. The ESC sends a report to the Standards Commission at the conclusion of their investigation. The ESC also has responsibilities in respect of complaints about MSPs and in regulating and monitoring how individuals are appointed to the boards of public bodies. Further information on the ESC's role and remit can be found on their website at ethicalstandards.org.uk. The Codes of Conduct for councillors and board members of devolved public bodies outline standards of behaviour expected of councillors and board members when they are acting in that capacity. Adherence to the codes ensures confidence in councillors and members and the local authorities and public bodies they represent. It allows the public to have confidence that they are making decisions in the best interests of the public and not those of an individual councillor or member or their families, friends or associates. The Councillors' Code of Conduct, issued by the Scottish Ministers, applies to the 1,200 elected members of Scotland's 32 local authorities. Each designated devolved public body is also obliged to have a code of conduct for the members appointed or elected to their boards. This is based on a model code of conduct issued by the Scottish Ministers. The codes apply to over 1,400 board members of various types of public bodies, including individual national bodies, such as the Scottish Legal Aid Board, regional bodies, such as Highlands and Islands Enterprise, National Health Service Boards, Health and Social Care Integration Joint Boards, further education colleges, national parks, and regional transport partnerships. Both the councillors and the model codes of conduct can be found on the Standards Commission's website. You can make a complaint to the ESC that a councillor or member has failed to comply with their code of conduct. The codes outline the conduct expected of councillors and board members and cover a variety of topics. These include the requirements for councillors and board members to behave respectfully towards everyone, including their board member and councillor colleagues, employees of their local authority or public body, and that's when they are acting in the capacity of a councillor or a board member. The codes make it clear that bullying and harassment is not acceptable. In relation to gifts and hospitality, the codes only permit councillors and board members to accept gifts or hospitality in very limited circumstances. This is to stop people or organisations from giving them gifts or offering hospitality to try to influence the decisions they make. In relation to confidentiality, councillors and board members are often told things in confidence or given information that is not to be made public at that time. The codes require them to keep such information confidential, even if they think it should be made public. Registration of interests. Councillors and board members must record certain interests that could affect their discussion or decision making in their role. Declaration of interests. Councillors and board members may have connections to matters being discussed by their council or public body through their relationships with other people and organisations. Any conflicts of interest should be declared publicly and councillors and board members must not take part in discussing or deciding on a matter where an interest they could have could be seen to influence them. Lobbying. Councillors and board members may be lobbied by people with a particular interest. The Code recognises this and sets out rules about how councillors and board members should deal with anyone who attempts to lobby them. In relation to quasi-judicial and regulatory decision-making, the Councillors' Code outlines what councillors can and cannot do when making decisions on quasi-judicial and regulatory matters, such as planning and licensing applications. It's important to note that the codes govern the conduct of councillors and board members. However, the codes do not cover complaints about decisions councillors or board members have made, and that's unless they have made the decision in an unfair way or not in accordance with their council or public body's policies or rules. This means that you cannot complain, for example, about a councillor who has voted against a planning application you submitted, unless you consider they made that decision unfairly. The codes also do not cover the performance of councillors or members, such as how well they engage with their constituents or service users. For example, you cannot complain that a board member has failed to reply to correspondence, as the code does not require them to do so. The codes don't cover complaints about the service provided by a council or public body, and also they do not cover complaints about decisions made by councils or public bodies, or complaints about council or public bodies' employees, or the conduct of a councillor or member who is acting in a purely private capacity. There are two bodies involved in dealing with complaints about breaches of the code. That's the Ethical Standards Commissioner, or ESC, and the Standards Commission. Anyone can make a complaint to the ESC. If you think a councillor or member has breached their code of conduct, you can make your complaint to the ESC's office via their website at ethicalstandards.org.uk/complaints. You will be asked to identify which parts of the code you think have been breached. Before making the complaint, you should look at the wording of the applicable code and also the Standards Commission's guidance and advice notes. Upon receipt of a complaint, the ESC will firstly decide whether the complaint is admissible. More information on that will be provided on the next slide. If a complaint is accepted as admissible, the ESC will investigate it by speaking to witnesses and gathering evidence. The ESC staff will guide you through the process. It is possible that they will ask you for more information or may interview you. The ESC's office has published an investigations manual, which is available on their website. This sets out how investigations are undertaken. The Ethical Standards in Public Life, etc. Scotland Act 2000 requires that investigations shall, so far as possible, be conducted confidentially. The ESC will ask that all parties to a complaint respect this requirement. The ESC has published admissibility criteria and will accept a complaint for investigation if it meets those criteria, being that the complaint firstly concerns the conduct of a councillor or board member when they are acting in that capacity. Secondly, is made within a year of the conduct or the end of a course of conduct. And thirdly, if it could, on its face, amount to a breach of the codes if established. The ESC may also reject the complaint as inadmissible if the councillor or board member in question has passed away or is incapacitated. When the ESC has completed the investigation, they will send a report outlining their findings and conclusions to the Standards Commission. Members of the Standards Commission are then obliged to make a decision under Section 16 of the 2000 Act about whether to either direct that further investigation be undertaken, hold a hearing, or do neither, which means that no further action will be taken on the complaint. The Standards Commission will hold a hearing if it considers it is in the public interest and proportionate to do so. The Standards Commission may direct the ESC to carry out further investigation in any of the following circumstances. If it is unclear from the report as to what the ESC's findings or conclusions are, if it considers there are any material facts that have not been sufficiently explored, or that insufficient attempts have been made to obtain and analyse evidence that may have a direct bearing on the question of whether there has been a breach of the Code, if it is not satisfied that all aspects of the complaint that could amount to a breach of the Code have been investigated and covered in the report. The Standards Commission may also choose to take no action if it concludes that further investigation is not required, and also that it is not in the public interest or proportionate to hold a hearing. It may do so in cases where it is not satisfied on the face of it that the alleged conduct would amount to a breach of the Code, even if established, or if it is satisfied that the alleged breach of the Code is minor, technical, or inadvertent in nature, and that there is evidence that the respondent admits or accepts that their conduct could potentially amount to a breach. When the decision to do neither is made on all aspects of the referral, the Standards Commission will write to the councillor or board member in question, the ESC, the Chief Executive of the respective council or public body, and the complainer to advise of its decision and reasons. The Standards Commission will publish a written decision on its website outlining its reasoning before closing the case. Neither the respondent, councillor or board member nor the complainer will be named in the decision. The purpose of a hearing is to determine whether the councillor or board member has breached their code. Hearings are usually held in public at the headquarters of the council or public body in question. The Standards Commission's hearings are conducted by a panel comprising of 3 of its members. The panel will conduct the hearing in accordance with its hearing rules, which can be found on the website. The ESC and respondent councillor or board member can call witnesses to give evidence at the hearing and can also make submissions on whether there has been a breach of the Code. If the Standards Commission decides to hold a hearing, the complainer may be asked to appear as a witness and give evidence. More information about appearing as a witness can be found on the Standards Commission's website. After considering all relevant evidence and submissions, the Standards Commission's hearing panel will decide whether there has been a breach of the Code. If a breach is found, the Standards Commission will decide whether to censure, suspend, or disqualify the respondent councillor or board member. The Standards Commission publishes written decisions of all hearings it has held. These outline the hearing panel's decisions and reasoning. Both the codes of conduct for councillors and board members are available to download on the Standards Commission's website, along with guidance, advice notes, e-learning modules and videos on their provisions and different aspects of the ethical standards framework. The Standards Commission also publishes information about its forthcoming hearings, its written case decisions, and its quarterly standards updates. You can follow the Standards Commission on LinkedIn and on Facebook. And if you have any inquiries on the Code or the Standards Commission's work, these should be directed to our General Inquiries address, which is inquiries@standardscommission.org.uk. Thank you.